Maybe as a transition thought, as we look at special permit conditions and mitigation strategies and conservancies, what occurs to me is that they really come as a response to some of the complexities that we're seeing in the legal world and looking for alternatives. And if I could just ask you if you wanted to take any conversations outside, I'd appreciate that. So with that, without too much more introduction, I'm going to turn it over to have a discussion about emerging case law trends. And to do that, I'm going to introduce our moderator, Mike Gershon, principal with Lloyd Gosselink. Let's welcome him this morning.
Good morning. So we are fortunate to have three experienced litigators on this panel. I'll be moderating. We have a dozen cases that we're going to dig into, all that are pending. There's some common themes among some of the cases. Our goal is to provide the audience with some takeaways, some things that we can learn about these cases as they're working their way through the court system. Please take a look at your summit brochures to see the vast experience of each of these speakers. They are all involved in one or more of the cases that we're going to discuss, so you'll hear some insights. Some of us are opposed to one another, so I guess fortunately I get the opportunity to cross-examine one of my opposing counsel, and hopefully we do add some value to what you hear today, and there's some good takeaways. With that, and given our limited time, we're going to launch into it. Celina Romero, to my far left, your right, will be beginning. Greg Ellis and Stacey Reese are your panelists. All right, Celina, who is involved in this first case involving the Edwards Aquifer Authority, is going to kick off the discussion.
Sure. Good morning, everyone. I represent the plaintiffs in this case, the Uvalde County Underground Water Conservation District, and Carolyn and George Legoski, who are irrigators and farmers in Uvalde County who hold both Edwards Aquifer irrigation permits as well as irrigation permits from the Uvalde Underground Water Conservation District. Other interveners in this case are the City of Uvalde and the County of Uvalde. And before we dismiss the board members individually, Mike Gershon was actually representing one of the EAA board members who had voted in opposition to the rules in question. But we swiftly disposed of Mike by dismissing his client. So
thank you.
You're welcome. You think, right? The central question in this case is whether EAA's conversion rules violate the EAA Act's mandate that 50% of an irrigation water right remain with the land. The statute in question is a specific statute. It's unique to the Edwards Aquifer Act. What the statute provided is that 50% of an irrigator's initial regular permit, 50% of that right would remain with the land and run with the land and be used in accordance with that initial regular permit. The EAA, over a course of time, beginning in 2001, has developed a set of rules that allow the severance and conversion of that, what we call the base irrigation water right, and allow that to be sold in the free market. Early on, those rules allowed such a severance when the land itself was developed. The EAA's thinking on that was if you had developed irrigation farmland and you no longer irrigated that land, it didn't make sense from a public policy perspective to allow that water right to remain stranded with that land, in other words, not usable by any other entity. So it set up a set of rules that when that land was developed, that the water could be severed and then sold. Over the course of time, the EAA has relaxed those rules. It recently adopted amendments to those rules in December of 2017. The district opposed those rules, and those rules now provide that the land itself does not need to be developed in all circumstances in order for the severance and conversion to occur. In fact, in one instance, an entity with eminent domain authority, think of a city or a railroad, that acquires that land can just convert that water, sever and convert that water without any development taking place on the land. The public policy issue that's at play here is whether or not these transfers and conveyances of these water rights will impact the economy of Uvalde County and the available water supply of Uvalde County. Just by sheer market forces, it is expected that if any sales of water take place, it will be from the west to the east within the EAA region. And once those rights are sold out of Uvalde County, it's highly unlikely those rights will ever come back. So Uvalde has an interest, a strong interest in seeing that the EAA recognize this issue, and we've asked the court to look at their regulations and see if they are indeed invalid. We have a temporary injunction order that's been issued by the court, and that injunction enjoins the EAA from being able to approve and process conversion applications until the hearing on the merits. The hearing on the merits is December 4th. We hope to get to that merit hearing quickly. We do expect that whatever is the outcome, that there will need to be some remedial legislation to address all parties' interests.
So this case involves, in some respects, export of water. Not physically through a pipeline, but to the extent that we're moving water from the western part of the authority into the east. There are policy issues with that. The Edwards Aquifer Authority isn't governed by the same statute. This case isn't defined by 36.122, the export statute, like we might see. I'm interested, Greg, if you're comfortable, giving your thoughts about, how this issue was framed up back in the early 90s when the EAA was first set up, and the policy discussions and the testimony at the Capitol were looking at this issue.
Well, when we first, I was general manager of the Edwards Aquifer Authority when we adopted the first rule, and the whole idea of stranding a water right that could never be used created the problem, potential takings issues. If you tell somebody, here's your water right, but you can never pump it, that's about the same thing as saying you don't have a water right. And so we were concerned about people filing lawsuits against the EAA saying you've taken our water by virtue of this statute, and so we came up with a plan that if the property absolutely could not be irrigated, then that right should be made marketable. And I want to point out, my takeaway from this in this whole situation, a lot of people have pointed to the EAA as a great market for water rights, and like the Bush School report talked about using market forces as a way to allocate groundwater rights. The problem with that is we don't have the same levels of demand for that water or the ability to pay for that water. The farmers are able to pay, in some cases, barely what it costs to lift the water to the surface to be able to irrigate their crops, and anything more than that, they're not going to be able to afford to irrigate. Cities can pay quite a bit, much more than that, because they're going to be selling that water to their customers. By the way, Ozarka can pay a whole lot more than that because they're going to put it in little plastic bottles and sell it at $1 million an acre foot. So if you want all of your water delivered in little plastic bottles, let's use market forces as our sole means of allocating groundwater. I think that this is, anytime a district is sued because they're saying their rules have gone too far astride from what the statute allows, there's always something on the other side pushing back saying why we had to do that. In my opinion, there's got to be some sort of mediation in here, and I'm hoping that we find a legislative solution to this that we can get out of the litigation.
Well, and let's move on because we have 11 more cases.
Okay.
But with that in mind, it's my understanding that there are several
I'm
other,
biting my tongue, but I'll let you move on.
Well, but and we can take it outside. That other panel was so friendly and interested in mediation.
Yeah, I appreciate it.
We'll take it outside.
I appreciate Dirk mentioning the peacemakers and then said, and here's the attorneys.
That's right. But there are several stakeholders, both private landowners and other governmental entities, that are likely to intervene in the case, and stay tuned. Let's move on to another EAA case that's of interest. Greg, if you could help us with this case.
Well, when they first created the EAA, the biggest problem they had was trying to find a way to create representation. The first act that passed changed the old Edwards Underground Water District Board from elected to appointed. The appointed board was enjoined because of violations of the Voting Rights Act. It was going to dilute minority voting strength. So they went back to the legislature, and the legislature changed it from an appointed board back to an elected board, but they had to find a way to balance the interests. The Edwards Aquifer in that area is kind of divided into three very distinct interests. You've got the western part, which is primarily irrigation. You have the central part, which is primarily municipal. Then you have the eastern interest, where those spring flows need to continue flowing, both for endangered species, but in my opinion, more importantly, for the people who live downstream and use that surface water that comes out of those springs. So the EA is balanced between those three interests. You have 4 board members from the west, 4 from the east, and 7 from the center. The problem is that something like 90% of the population is from Bexar County. So on the one man, one vote scale, it was very disproportionate. LULAC filed a lawsuit saying that you're violating the one man, one vote concept. That went to federal district court. The federal district judge, not too long ago, ruled that it was in fact exempt from the one man, one vote requirement because it is regulating a natural resource, and that regulation requires balancing of those interests over that resource. So he found that the act and the allocation of those board members was constitutional and didn't violate one man, one vote. I was kind of surprised that he held that even the districts within those separate regions didn't have to be balanced by one man, one vote, but that's what he decided. So I think we're waiting on the whether or not there's going to be an appeal from that.
All right. End up. We are fortunate to have two-thirds of this panel, myself included, has had some touch to this case. Stacey Reese is going to walk through the next couple of slides involving multiple rounds of administrative litigation and litigation at the court. Stacey.
Thanks. This is a case on standing, and how does a third party or a landowner demonstrate standing to protest a groundwater permit application? It's currently pending before the Third Court of Appeals in Austin. Last fall, I'm sure you guys probably heard that the Bastrop County District Judge reversed Lost Pines' denial of party status, which effectively revoked NDOP's permit that the district had issued. So NDOP and the district appealed the Bastrop County District's judge's opinion to the Third Court of Appeals. They appealed on the standing issue. NDOP also raised a jurisdictional argument, which we'll cover in just a minute, but I wanted to go into the facts about this standing case in case you haven't been following it. They're pretty interesting. These 4 landowners sought to participate as parties in a contested case hearing on NDOP's applications that were originally filed way back in 2007. So this has been going on for over a decade. The 4 landowners, none of them had a well in the Simsboro. None of them had an intent to drill a well in the Simsboro formation, which was the formation with which NDOP sought to pump water. Only one of those 4 landowners actually had a well, and it was in a much shallower formation. And a common fact among all the landowners was that it was very cost prohibitive for any of those landowners to drill a well in the Simsboro. So the district denied party status after a contested case hearing with an ALJ, saying that they had not demonstrated a particularized injury. There are sort of 4 elements that you need to establish to demonstrate standing. No one contested that these landowners who owned land overlying the aquifer had the legally protected interest, but there was a big question about whether these particular facts rose to the level of this particularized injury that was necessary in order for them to participate. What's currently happening at the third court is all the briefing has been completed. The briefs were submitted yesterday. The court has denied oral argument. The district and NDOT both requested oral argument on the standing issue. The district denied that. The court denied that. NDOT also raised a jurisdictional argument that has not been sort of it's a new argument in this appeal to the third court. They, and I have represented NDOT throughout this process, but NDOT contends that the landowners failed to file their right for judicial review within the 60-day window, so therefore they're jurisdictionally barred. So this whole process we've been going through, the argument is that they don't actually have a right to an appeal. In the Bastrop County proceeding, the landowners did what is called a judicial admission, that a certain particular order was the final order. And that order is the order that triggers the deadline for filing a right to judicial review. And there's several different versions of, which one was the final order throughout this whole process, because they had originally filed 4 different appeals, 3 of which were consolidated and 1 which was ultimately non-suited. But the first written order issued by the district denying the party status was admitted as being the final order. And based on that calculation, the landowners would not have filed within the 60-day window under Chapter 36. So it'll be interesting to see. Some great minds that I've talked to have opined that because the third court has denied oral argument on the standing issue, that means that perhaps they're going to rule in favor of NDOT on the jurisdictional argument. The district did not raise a jurisdictional argument in this appeal. They raised several different jurisdictional arguments at the district court level, all of which were denied, and there were no interlocutory appeals from that. So we will see if the third court does rule in favor of NDOT on this jurisdictional bar issue, then the landowners their relief would be, or remedy would be, to petition the Texas Supreme Court to review that decision. And it'll be interesting to see the outcome of that. Perhaps we may get some language from the court that's instructive on these particular facts, but there is a scenario where we won't get a ruling on standing in this case.
Let me provide a little bit of context. This case involves an application that was filed several years ago. NDOT had requested 56,000 acre-feet from the Simsboro, the Carrizo Aquifer, in the Lost Pines Groundwater Conservation District. Some of the other cases that we'll be talking about involve relatively large quantities of water that have been requested. Think about, in the crowd, month in and month out at these Groundwater District Board meetings, what plays out. I mean, my hunch is that there are dozens of applications pending before Groundwater District boards every month. The boards are making decisions when landowners come in that may live next door to the proposed permit holder, folks who are wanting to protest, and decisions are made on whether to let those folks protest. And it's as simple as that. Interestingly, this litigation occurred because of the concern of several landowners and an environmental group over the 56,000 acre-foot permit request. Let me ask this of the panel. Is the standing test itself well settled, or is there the possibility that could evolve?
I think it's well settled. That's certainly the arguments we're making, but I defer to Greg and Celina because I'd like to hear their input.
I would like to agree with you, but I do think it is evolving, and how entities are impacted by the action of a groundwater district, I think, is being tested, and it's being tested in our case as well. The EAA has challenged the Uvalde district standing, the standing of the Legoskis in the city and the county, so on various grounds. So I think it'll be interesting to watch.
And I think also if the facts are a little bit different than the facts in this case, it might be, there might be a shift in the law.
Greg?
The question about how do I protect my vested property right if I don't have standing to file a protest is not going to go away. That's going to remain. The takeaway that I have for the districts out there is, and for the people who are applying for permits, do you try and get somebody removed from a contested case based on standing, or do you go ahead and let them have their contested case? Because if you kick them out, you could end up in the situation that NDOP is in now, where you may get to go back and do it all over again. So, if it's going to be contested no matter what, personally, my advice is let everybody in. If the only protestant is somebody who doesn't have standing, then go ahead and object to that, have them kicked out, then go, if you need to, go litigate that question. But if you're going to have a contested case no matter what, my advice is don't bother kicking anybody out, because you're just risking having to do it twice.
And I would have to agree that the standing test is well settled. We've had a number of cases over the years outside of the groundwater context that have helped to kind of shore up this four-part test that Stacey walked through. To Celina's point, however, the facts are so important when you're vetting that standing issue. Right. To Stacey's credit, the time spent in cross-examining and exploring what those interests were of those individuals was thorough and good, and I think got to the point that we're at now, which was each of those four protestants really didn't have much to offer in terms of the specificity, that particularized injury. I think as you see from the summary, I think it was really the facts that were weak for each of those individuals. Did I get that right, Stacey?
I would agree, and I noticed that LCRA has an application pending in front of Lost Pines, this district, for 8 wells to produce 25,000 acre feet, and that's set for hearing next month. So where the current status of the ruling with the Bastrop County District Judge, it'll be interesting to see if anyone comes forward to try to protest that and how the district will handle that. I haven't talked to Jim Totten about that, but...
I would just add before we move on that I think standing, I agree that the test of standing is well settled law, but how it's applied is different, and particularly when you're looking at standing with respect to protesting a particular application versus standing to challenge a water district's rules.
Thank you. We are in the Alamo City. I believe this picture up here is it the Alamo Village, Greg? I think this is your photo, or it was intended to be in the setting in Kinney County.
This was outside Bracketville, and it's kind of hard to see because of the clouds, but there are 3 of the big modern electric generation windmills up on the hill, and then there's this less modern water windmill down in the front. So I thought it was an interesting juxtaposition of the 2 different kinds of windmills. But yeah, this is part of an area about Bracketville. This case is another one that has been going on a long time. These people applied for permits in the early 2000s. The permits were eventually granted, but for less than the amount that was requested. A group of permittees filed an appeal that's now known as the Bullware lawsuit. There's, I can't remember now, 8 different permits being appealed. The district had said they were not going to issue any permits until the fees were paid. That got litigated. That was taken up to the 4th Court of Appeals and brought back down. The district lost that question. Once the final order is made, then they have to issue the permits. They can have a condition that the fees be paid. Then we had, as that question was pending in the 4th Court of Appeals, the applicants and 2 interveners who had joined the case and the district all reached a settlement agreement. They brought that settlement agreement back to the district court judge. The district court judge held a hearing and approved it. The day before the judge did that, 3 more interveners joined the case to object to the settlement. Part of what he did was he kicked them out on a motion to strike. I lost my mic. Oh, there we go. Kicked out on a motion to strike. And then they went back to the 4th Court of Appeals on that question, and they said, no, you can't strike somebody with less than 3 days notice of the hearing. So we had to go back and do that again. The parties all jointly filed a motion to strike. That was pending in front of that district court judge for 8 years. And he finally made a decision in June to strike those interveners. So now we're trying to move forward with the agreed settlement. Unfortunately, in the meantime, we had the City of Kyle case, the City of Kyle versus SOS, where the 3rd Court of Appeals said a district court judge cannot do an agreed final order that orders a district to issue permits at a certain level. All an appellate district court judge can do is remand the case back to the district for the district to take action.
With some guidance, with some limited guidance.
So we're now trying to craft an agreed final order for that judge to get this back in front of the districts. The district can finally make those permits final. One interesting thing I found in research on this, the federal level has what they call voluntary remand. The agency or the parties jointly can request the district court judge to remand the entire case back to the agency, either because they have reached a settlement or because there's been a change in the law, change in the rule, or a change in interpretation of a statute or rule that would create a different outcome for that permittee. Texas doesn't have anything like that. There's nothing in our Administrative Procedures Act that allows us to voluntarily remand the case back to the district court. So we have this odd situation where all of the parties currently involved in the case want it remanded, and we just can't figure out how to get it there.
Comment? Input? Similar to the end-up case, substantial amount of water. Cumulatively, what would you say the kind of ballpark amount of water being fought over would be? And what aquifer are we talking about?
Well, it's a lot for Bracketville. There's a few thousand acre feet involved here. I think it's less than 10. I think it's around 10,000 acre feet cumulative for the entire group. None of this currently involves any kind of export. This is all for use on the property. These are all historic use permits, and they were disagreeing over what that historic amount should have been, and should have been settled a very, very long time ago. But it's been a tough road. I took over this case in 2010 at the moment where we're filing our joint motion to strike the interveners. The case has lasted so long that two of the interveners just dropped off. They just quit, and we've had enough for going away. The third intervener is fighting like hell, and in fact has filed an appeal of their being stricken from the case. So that's going to the Fourth Court of Appeals as well. Bullware 3, we're going to call it.
Here is another series of lawsuits, both at the administrative level, one involving SOA, multiple federal and state cases that have multiple rounds. And Stacey, Reese is going to take us through these.
So this is a case that's pending. It's a standing case. The Cockrell case it's pending before the Pecos County District Court. And Cockrell Investments is a owner of a very large, I think the largest in the country perhaps, pecan orchard that happens to be right across the street from Fort Stockton Holdings, Clayton Williams family. And there were two hearings on Fort Stockton Holdings permits that came up for hearing as a result of a settlement agreement. And Cockrell Investments sought party status to participate in those particular hearings, and the district denied them party status. As a side note, I think that locally they call this sort of the battle between the billionaires, because as I understand it, Cockrell is an oil and gas family with this very large pecan farm, and Clayton Williams also is well known to be a billionaire. So locally, the two billionaires are duking it out, and sort of the district is in the middle. The two hearings that Cockrell Investments was denied party status for, the first one was a remand issue on an original application that had been filed in 2009, where Fort Stockton Holdings had sought a production permit in an amount equal to what it already had an existing historic use permit for. That was litigated, and if you want to go to the next slide, Greg, that was litigated sort of in round one. That went all the way up to the El Paso Court of Appeals. There was spin-off federal litigation. There was just fighting on all fronts. That particular application was resolved in a settlement last year, late spring and early summer. And that settlement agreement called for a remand of that 2009 application back to the district for the district to make a decision on it. The terms of the settlement agreement were that the district was going to ultimately issue the production permit to Fort Stockton Holdings in an amount less than originally agreed to, and Fort Stockton Holdings then was going to agree to file an application to reduce its existing historic use permit in an amount equal to the volume of the production permit, such that Fort Stockton Holdings originally kind of wanted two permits, the existing historic use permit and then a production permit, both in the same volume. And the district said, no, we're not going to give you two permits like that. So they worked out the settlement. When that came back for remand, Cockrell tried to participate in that hearing, and the district said, wait, this is a remand on limited scope of a 2009 application. You definitely missed the deadline. So the first part was sort of a time issue on whether the request was timely filed. And then the second hearing that happened was on the application to reduce the volume in the historic use permit. And when that came before the board on the hearing, Cockrell sought party status, and the district said, okay, well, you timely sought party status, but now, we don't think that you have a right to participate because we're having a hard time, you haven't demonstrated to us how a reduction in a volume of a permit has any adverse impacts on you. So again, you haven't demonstrated any sort of injury of how, giving you the right to participate in this process. So Cockrell appealed that. It's currently pending there. Another thing that has happened related to this issue, Cockrell also had appealed protested Republic's application that was filed along this process, and they had timely filed a protest to that and were actually granted party status and were going to participate in that contested case hearing. But as part of the settlement between the district and Fort Stockton Holdings and Republic withdrew that application. So Cockrell's petition now is all about how, why am I denied party status? This settlement is sort of a collusion or a backdoor way to block people from protesting these applications, given that the one that they had timely protested, Republic's, was withdrawn, and then they didn't have this injury necessary to participate in the reduction on the historic use permit. And I'll stop because there's other little bit layers, but I know you probably want to comment.
This is another decade-long litigation. Stacey, you should be involved in this case with your thorough understanding.
Well, I'm very familiar with Republic, but not in the case against Ed McCarthy. Let me just make that clear.
Whenever I think about this case, I always picture these two huge boxers in a boxing ring.
Here they are.
With a little guy in the middle, and every time the big boxers take a swing, they hit the little guy. And this is a perfect example of why we put into Chapter 36 that districts are entitled to their attorney's fees when they prevail in a lawsuit, because there's absolutely nothing the district can do right here. They either deny the permit or they grant the permit. They're going to get sued either way, and I don't understand why the ratepayers and taxpayers of the Middle Pecos District should have to foot the bill of that litigation. It's not their fault.
Okay, let's turn to another fight where the gloves are off. Lone Star Conroe, Stacey.
So this is a case that's challenging the validity of Lone Star Groundwater District's rules. It's currently pending in the Montgomery County District Court, where the city of Conroe and some other large utility producers sued the Lone Star Groundwater District based upon their adoption of rules that would impose production limits on these individual users, these individual large producers. And these rules that were adopted in conjunction with sort of an overall effort to reduce groundwater production and move pumpers over to surface water. There was an interlocutory appeal in this case that on some jurisdictional issues, and also in this case, the city of Conroe and the other large utility providers sued the individual directors, and that drew a plea to the jurisdiction, which was denied, and then appealed interlocutory before sort of the merits of the original case was decided. Up on the appeal, the Ninth Court of Appeals said, you know what, these claims against the directors should be dismissed with prejudice because they're immune from liability under the Water Code. So, and they decided some other issues as well, but when that came back down, what's going on in the case right now is that the validity of the rules has been briefed on cross motions for summary judgment by all the parties. And then, based upon the dismissal of the claims against the directors with prejudice, the district is seeking fees under Chapter 36 for their defense in pursuit of dismissal of those claims. The general manager was also involved in the case early on, but then he was non-suited. But the district, the groundwater district, wanted fees associated with, defending the claims against the general manager up until the time that she was dropped from the suit. So that the attorney's fees issue has been briefed, and the city of Conroe has come back and said, we're immune from suits for monetary relief. And so, we're immune from this suit for attorney's fees, basically. And then the district has come back and done some more briefing on it. There were 2 cases that came out earlier this year that talk about attorney's fees and whether or not by the city of Conroe initiating the lawsuit, did it waive that immunity to suits for monetary relief or not?
Especially since they sued the directors, when the statute clearly said you can't sue the directors.
Right. So that's an interesting issue. There's been extensive letter briefing back and forth to the judge and a lot of activity in this case recently on that. There's also another case about, you're only entitled to attorney's fees unless a statute expressly provides for it. And Chapter 36 clearly provides for a district to recover its fees. And the argument is that, well, you were defending the directors and so in the GM, and so therefore that doesn't expressly authorize fees. And the district is saying, but they were sued in their official capacity, so therefore it falls within that. So that's sort of an interesting question that is going to be answered pretty quickly.
My favorite part of this is if the city of Conroe is successful on their immunity claim, then all of the attorney's fees are going to fall on the non-political subdivision plaintiffs. So the attorney's fees are going to get paid either way.
Celina, take us to a pending case that has not yet been, where we don't know where venue will be.
Correct. Venue is at issue in this case. This is a case between the school land board and a landowner in Culberson County. He purchased land from the school land board, and the land was located in Culberson County. And as a part of the deed conveying that land, the school land board reserved all of its groundwater rights in that land except for domestic and livestock use. So that was allowed to be conveyed to the landowner. Nonetheless, the landowner, and this is the language of the deed here, but let's go back to the other slide for a second. The landowner nonetheless sold a large quantity of groundwater to an oil and gas production company for fracking purposes. He acquired approximately $450,000 in that transaction. The school land board then sued the landowner to enforce the deed to recover damages, penalties, and attorney's fees. As Mike mentioned, the current battle rests over where does venue lie for this cause of action. Is it in Travis County where the state of Texas filed its suit, or is it in Culberson County where the land is located, or is it in Reeves County, which is the defendant's domicile? So all of that is at play. The state of Texas in particular doesn't want to get hometowned on the lawsuit. But this is the language of the deed here, and I wanted to just walk through it with you a little bit.
And note the date reference, pre-Day McDaniel, when the folks were negotiating and drafting the language, which is interesting.
Yeah, the deed was, the land was conveyed in 2005. The deed was dated 2005, so that was pre-Day and McDaniel. So we didn't have that precedent, or the school land board didn't have that precedent to help guide it in the drafting of this deed. But you can see the reservation of right here. The Permanent School Fund reserves all rights to groundwater and groundwater leasing, except grantees shall have the right to groundwater for residential and domestic purposes only. And then it goes on to say that the easements and restrictions and covenants in this deed run with the land. So that is in my view, that's a pretty strong reservation of rights in the school land board. And apparently the landowner is arguing that he's arguing issues of estoppel and waiver, and the landowner has sent a check back to the school land board for approximately half of that $450,000 payment it received from the oil and gas production company. And because of the passage of time between the date when the school land board or the state of Texas deposited that check and then filed suit, the landowner is arguing that they had impliedly accepted the full payment for the landowner's breach of the deed. So those issues are at play.
And in the interest of time, I'm going to press forward. This is a profound case in as much as the takeaway is Be careful in your drafting and your negotiating, in your contracts and your deeds. The Fazzino
And there's going to be
case-
lots of litigation on these reservation clauses in the years to come, the decades to come.
that date back years to the point of that case. I believe Greg is going to cover the Fazzino case.
Well, this is the case we've been predicting for a long time, where we have an adjoining landowner, adjacent landowner, who is complaining of the permit granted to the city of Bryan and the fact that that permit would allow drainage of their property. The city of Bryan has a very small piece of property where they put in a large well field. The district issued the permit to allow that pumping, and the adjoining landowner is essentially saying through this lawsuit, we want one of two things: either restrict their permit to the same amount per acre you would give to me, or give me the same amount per acre that you gave to them. And we have a vested property right to our groundwater. You're allowing them to drain that groundwater. Therefore, you're causing a taking of our property through the issuance of that permit. It's interesting that they're claiming damages of $100,000. We just saw $450,000 in the other case in selling for. So I'm not sure where that number came from. But we have
this picture.
There you go. We have a couple of battles of the experts on here where this is kind of hard to see on the slide, but the expert testimony is there'll be such a minimal amount of drawdown from the city of Bryan's wells that it can't possibly impact anything unreasonably off-site. And the other argument is, of course, that's because it's continually recharging in. If this were an oil and gas formation, then they would have the right to come in and order unitization, and they'd have the right to claim payment for the money that they are losing because they're not pumping the oil and gas and the neighbor is. But in this case, does it really impact anything on the Fazzino's property for the city of Bryan to continue to pump at this level? This is going to be a really interesting case to follow.
So what are your thoughts on the fact that this district, over a decade ago, issued dozens of permits for both historic use, for existing wells, and has issued dozens of permits for new use as well? Could this case have the potential for unraveling the expectations of those permit holders?
Absolutely. I think what I believe what the goal is of the plaintiffs here is to try and force this district to follow a pure correlative rights system, where the only amount you can pump is based on the amount of surface acreage that you own. And if they achieve that, then all of those permits are undone, at which point those historic users will probably end up filing takings lawsuits against the district because their investment-backed expectations are not being able to be met on a pure correlative rights basis on a permit. So this is what we predicted when the Day case was decided, that we're going to end up with a fight between adjoining landowners, some of whom have historic demands that far exceed what their property could otherwise support on a correlative basis, and those who want to try and force us to into correlative rights permitting.
We've got just 2 or 3 more minutes.
Okay, this is an appeal from a...
This is an important case, as is the next case.
This is an appeal from a permit decision that was made where the permittee was originally granted a permit based... All the permit said is, here's how much your rate of withdrawal can be. There was no limitation on the annual amount that could be withdrawn. A decade later, they came in with rules that said we now have to start putting limitations on how much you can produce. They added that limitation to this permit. This permittee then appealed that. We had a contested case hearing. They're wanting the full amount they could produce under the rate of every one of their wells of 2,096 acre feet. The district is saying we're going to give you a permit for 301 acre feet, which is more than you're currently producing. Plus, we're going to give you a 27 acre foot variance. Plus, if these other conditional things you say are going to happen in the future, creating new demand, we'll give you an additional 400 acre feet on top of that, but it's not 2,096. So they filed an appeal and a takings claim. If they don't get their 2,096, they want compensation for the amount that they don't get. That is currently in front of the district court. The district has filed a plea to the jurisdiction on that because the surface estate owner went through bankruptcy, and the new surface estate owner has now applied to transfer those permits into their name, which would make this appeal moot.
Thank you, Greg. I didn't mean to rush that. Please visit with Greg during the break more about that case if you have an interest. Celina is going to wrap us up with an interesting case that crosses state borders.
Right. This case implicates and rights under an interstate compact between Texas and New Mexico and Colorado. It implicates rights under an international treaty between the United States and Mexico, and it represents a conflict of interest or tension between groundwater and surface water users. So we've got all levels of interest represented here. It is an original action case in the U.S. Supreme Court. The Supreme Court has been using special masters to handle a lot of the preliminary briefing and discovery activity that takes place in these proceedings. We heard a quote from Will Rogers this morning, and I couldn't let the moment pass. This case also has another quote from Will Rogers. Justice Gorsuch delivered an opinion of the Supreme Court on a preliminary matter in the case on March 5th of this year. His opening line is, Will Rogers said that the Rio Grande is the only river he knows of that requires irrigation. So there you go. If you have any takeaway at all today, let that be it. Under the compact, the state of New Mexico is required to deliver water to Elephant Butte Reservoir. A dispute has arisen with Texas and the United States because in between the outfall of the reservoir and the Texas-New Mexico boundary, groundwater development has occurred and surface water diversions are occurring. And so those groundwater...
Groundwater as in 50-foot deep well, 10 feet from the river, right?
It is groundwater that is alleged to be hydrologically connected to surface water. Sorry, yeah, that is the connection. And so Texas is complaining that its allocation of water under the compact, and then the United States as well, is arguing that their receipt of water from the Elephant Butte Reservoir has been diminished by these diversions. We don't know what's going to happen yet. It's gone back to the merits before another special master, so this is still in progress.
Okay, I believe we have a question from Sarah.
We do. And because we only have time for one question, I'm going to attempt to combine two questions into one because they're on the same thing. So bear with me for a second. The first one is, so what's the basis that the Bastrop District Court overruled the district's denial of party status? And the second part of that, in conjunction with it, is...
Don't we all want to know?
Yes.
Don't we all want to know?
Right. And then the follow-up is, was the judge a district court or appellate judge? What's the difference between the two? And if we do see that loser pays bill, would it be a district court or appellate court judge that determines awarding attorney's fees?
About the Lost Pines decision, the Bastrop County District Judge did not give us a reasoned opinion. There was a lot of discussion about whether we should request the judge to file some objections and get the judge to give us a reason, but he did not. The difference between the Bastrop County District Judge and an appellate judge, in the administrative law process, the Bastrop County, the district court judges actually act as an appellate court in an administrative appeal, just like the further appellate courts. In non-administrative law context, the district judges act like trial judges. So technically there was a review of, a record was already made at the district that was reviewed under a substantial evidence rule by the Bastrop County judge. And then there's a right to appeal that to the true appellate courts, the traditional appellate courts of Texas, and then ultimately perhaps to the Texas Supreme Court that I'm told only, Justice Lehrman says they only take cases that can significantly impact the jurisprudence of Texas. And I'll let you answer the attorney's fees issue.
Yeah, the attorney fees question, the district court judge will determine the attorney's fees and has pretty much full discretion as the amount of those attorney's fees.
Are any of them elected?
They're all elected. We have all elected judges in Texas.
The boundaries on those attorney's fees, though, are that they have to be reasonable and just.
Right. Yeah, all
State
court judges and justices are elected in Texas.
The federal judges are appointed.
And all my fees are reasonable. I don't know what you're talking about.
Okay, Stacey, help us wrap up. This is our final case.
Yeah, there's not much to report on this case, and this case really just stands for this is an interesting way to utilize the Public Information Act to gain information. There's a right to mandamus relief under the Public Information Act, and this Save Our Springs group sued the Water Supply Corporation seeking mandamus relief, saying, give me this information about the Vista Ridge project, the specific easement agreements, we want minutes from your board meeting, we want the location of the pump stations. They sought an AG opinion who said, hey, you're not subject to the act. We agree with you at this time because you're not yet providing water and you're not yet subject to or exempt from the ad valorem tax. So it's been sitting on the docket for a couple years. Nothing's happened. I think there's a jurisdictional argument that there is no basis for mandamus relief because the elements in the statute have not been met. So you can go back and read the Public Information Act if you're interested in that particular, or talk to me on a break and I can give you a little bit more detail about that.
Thank you, Stacey.
Yeah.
Greg, Celina.
Yeah, thank you.
Thank you.